Here we go again. Just so that I've got something to talk about, the Lord Chancellor has for the fourth time this year just raised the rate which is used to calculate interest on compensation you can collect for non-injury losses after an accident, loss of earnings, physiotherapy fees, that sort of thing. It's swingingly called the Court Funds Special Account Rate. Well, make sure you or your lawyer are seeking for maximum interest you can go for when claiming against the insurers of the person who negligently caused your accident. You can see all the rates which now apply going back to the 1st of June 2020. You can print it out and use it to wrap up your fish and chips. Landlords are in a dilemma. There's a bill before Parliament that will tip the balance of power in England in favour of private tenants as against their landlords. Well, should landlords withdraw from the rental market and sell up or apply for planning permission to change the use of their property to a fish and chip shop? But remember, cod is very pricey. As you'll have gathered, I've got a thing about fish and chips at the moment. Of course, the law hasn't changed yet, so calm down. The new bill, the Renters Bracket Reform (close brackets) bill, must progress through Parliament, and there could be many amendments yet. Once it lands up on the statute book, regulations and court procedural rules will need to be passed. The intention is to implement the new law in two tranches, once the regulations and the rules are ready. Initially, it will only apply to tenancies granted at least 6 months after the government says it's ready to bring the legislation into force. Subsequently, and we don't know how long this will take, but it could be a year plus, the government will apply the proposed new law to old tenancies. Well, the main reform is the abolition of no-fault possession. Generally, a landlord can now get their property back from the tenant through the county court once any guaranteed period to occupy has come to an end. That's having given the tenant at least 2 months written notice. No more under the proposed new law. Well, what of possession because the tenant's been at fault? First, rent arrears. Currently, with at least 2 months arrears, both when notice has been given and at the court hearing, the judge has no option but to make an order for possession, and that won't be suspended. Well, the proposed change is that mandatory possession will be ordered, but if 2 months' worth of rent are unpaid for at least 1 day on 3 or more separate occasions over a period of 3 years before the landlord has served notice. Got it? The arrears will have had to dip under the 2 months between those various occasions. Persistent delay in paying rent, or just simply that there are some arrears in existence, will remain grounds for possession, but here the court won't be compelled to order the tenant out. It will have a discretion about what to do, and a landlord then will probably only achieve a suspended order of possession for these grounds at the best. The proposed new law will actually make it easier for a landlord to obtain possession against a tenant who is, let's be polite, a confounded nuisance. That's because it will no longer be necessary to wait for 2 weeks from giving them notice before starting a court case for an order that they go. And there's another reason. Currently, the landlord must prove to the court that the conduct complained of is likely to cause a nuisance or annoyance to the landlord, to someone else living in the home, or Auntie Vera when she's visiting for tea and crumpets, and there are a couple of others. Instead, it will be sufficient for the landlord to prove that the conduct is just capable of causing a nuisance or annoyance to any of these people. Is that a big deal? Well, it is. It's a lower bar. Suppose the tenant is a charity contributing angel who helps pedestrians across the road and polishes their microwave door with daily regularity, but still the landlord wants the property back. Well, it will generally be possible, provided formalities are observed, for the landlord to obtain possession through the court if they can prove that they want possession so that they or a close family member can live there as their own or their principal home. Or it will generally be possible to achieve possession if the landlord intends to sell the property, and no porky pies about that intention will be permitted. Landlords will still be able to increase rents to market rates, but there will be stronger protection for tenants where the landlord is going over the top, with a right of appeal to the tenant to an independent tribunal. As things presently stand, landlords who are met with tenants' resistance to a rent increase can simply serve the tenant with a 2-month no-fault notice, but that particular device will no longer be available under the proposed reforms. It's to be hoped that landlords will stick in there and not take fright. Oh, I nearly forgot. Tenants will have the right to request that the landlord allows a pet in the rented property. This should not be unreasonably refused, but pet insurance can be insisted on to cover any damage to the property. Phew! Workers who become pregnant during their employment will have greater protection against losing their job through redundancy as from the 24th of July 2023. That's subject to regulations which are awaited under a new act, which will mean that the right of first refusal on a suitable alternative vacancy where one exists will apply as from the date at which the employer is informed of the pregnancy until probably 6 months after returning from leave. And all this will apply not only during maternity but also during adoption and shared paternal leave. An employer who breaks the new law can expect to face a claim for unfair dismissal. In my next video, coming soon to a device near you, why you may be underclaiming for personal injury, escaping a tax penalty or getting it reduced, and the big shake-up with legal costs coming into force on the 1st of October 2023, why the changes there may be bad for your pocket and how you might lawfully avoid them.
Haven't you forgotten something?
Well, I've had my breakfast.
No, you haven't mentioned your book.
I can't mention that.
Yes, you can.
I won't mention that.
Oh, please.
Just quickly. The Return of Breaking Law, How to Win Your Case or Lose Well.
You normally say it's the book what you wrote.
I know. You might like to buy a copy.
I don't need to. You gave me a copy, thank you.
Scrooge.
Yeah, stop messing about.